Hello, nation of immigrants. Today we've got some exciting news. I've been checking the news and it's kind of amazing. So much action is happening in immigration. Last night I thought I was going to spend this episode talking about birthright citizenship and different possibilities there. There have been some news and action there. We'll probably address that soon. But then today in the office, we got some very interesting news about administrative closure in the immigration courts. I've been meaning to talk about the immigration courts for a while. And for those of you who are aware, and maybe not, if you're listening to this, the idea is to learn things you maybe didn't know. The immigration court backlog is enormous to the point that I personally have cases that aren't going to be heard until 2023 and beyond. So today we're going to talk about how a decision in the Fourth Circuit may decrease that immigration court backlog. Welcome to Nation of Immigrants.
You're listening to Nation of Immigrants.
America is a nation of immigrants.
A podcast about U.S. immigration law with your host, Jacob Tingen.
All right. So once again, as I mentioned, we're talking about the immigration court backlog. And one of the things that is important to recognize is there's like a million cases in our nation's immigration courts. There's only about 400 judges, I recently read. And so it's interesting when you go to immigration court, particularly when you get new judges, it's kind of fun because they're like, my court won't be continuing the way other courts do. But when they have a master calendar hearing, and we'll talk a little bit more about that, with 40 individuals, and they have to schedule an individual hearing for each of those people, after a month of those kinds of hearings, their calendar is booked out until 2022, 2023. Now, one of the topics I've wanted to address for a while is how the current administration, through this certification power of the Attorney General, is trying to influence in this enormous way how immigrants go through removal proceedings. So, and this is a topic we'll go in depth on later. I've already been kind of charting out and planning out kind of a whiteboard episode that we'll do in our conference room. But for today, some news came out about a particular issue, and we'll address it this way. First, some background. The Trump administration has taken a very hardline stance on immigration, and a couple of episodes ago, we talked about prosecutorial discretion and how this hardline stance, we're not going to let anybody go, everybody's a priority, has actually turned into a reduction in the number of deportations we're seeing in the country. And that same attitude, this hardline stance, is turning into the same kind of inefficiencies in our immigration court. So due to some administrative procedures and regulations, and again, this podcast is not to get too much into the legal weeds, and we'll get into the specifics later, but due to some quirks in the law, the Attorney General can essentially pluck cases from the immigration court system and then redecide them himself. Jeff Sessions was very active in doing this. The Attorney General Barr is also fairly active in doing this. And we're seeing that attorneys general under the Trump administration have been taking cases and deciding them. So what does this have to do with today and the immigration court backlog? Well, one of the cases that Jeff Sessions plucked out of the caseload in the immigration courts was a decision called Matter of Castro-Tum, because it's not like people versus so-and-so. It's not a, AVB, case caption title for immigration court cases. It's always just in the matter of so-and-so. So in the matter of Castro-Tum, the person by the last name of Castro-Tum, basically it was a case about administrative closure. Now, let's harken back to our other episode where we talked about prosecutorial discretion. That was an option where immigrants who were in removal proceedings, if they got to court and the DHS attorney, the attorney for the government, decided, well, this immigrant is not a priority for removal. We're going to focus our limited resources on criminal offenders, criminal immigrants, and we're not going to let this mother with 4 children be deported. She's not really a priority, so we're not going to focus time and attention on her. Then the DHS attorney would work together with the immigrant and their lawyer, and they would ask the judge to administratively close the case. Okay? And so that was administrative closure. It's a practice that's been around since the 80s, 1980s. The courts have been deemed to have this authority, and it was just something that kind of run-of-the-mill happened all the time for different reasons. One reason that somebody might administratively close a case, outside of the aspect of prosecutorial discretion under the Obama administration, but just one particular case, the matter of Avedisian, was about a person who had a pending case outside of the immigration court. And the outcome of that immigration petition would determine whether or not she would even need to go through removal proceedings. And so what that case addressed was, well, if her case file keeps getting switched back and forth between departments of the Department of Homeland Security to the court and then back to the office to administer a decision, then it would never get decided on because the file would just shuffle back and forth between the court and then the office making the decision. And so these kind of government bureaucratic inefficiencies made it so that administrative closure was necessary. And so then, we also recently talked about U visas. 4 years to have a U visa decided. It made sense to administratively close a U visa case, particularly a U visa case that's strong, and see how that turns out before we make a decision in the immigration courts. So administrative closure made sense in a lot of different contexts. And it's been something that's been done for years and years and years. Lots of precedent built up around the ability of the courts to do it and implement it. Well, along comes Jeff Sessions, hardline immigration stance that the Trump administration is projecting. And Jeff Sessions plucks a case that had been administratively closed, matter of Castro-Tum, and decides, you know what? Immigration judges don't have authority to do this. They can't manage their dockets. Nowhere in the law does it say that they can administratively close cases. And it doesn't specifically say they have the power to administratively close, but as we'll see here in a bit, the Fourth Circuit points out that immigration judges and the BIA, the Board of Immigration Appeals, have power under certain regulations that say they have any authority necessary and proper to fulfill their duty and manage their docket. Well, so matter of Castro-Tum said that they didn't. And that was kind of a shock to the immigration courts and to many of the deportation defense attorneys. What are we going to do now that we have all of these cases? We know that timelines for processing cases last forever, depending on the relief you're seeking with USCIS. It can take 6 months, a year, or more. And so it just frankly makes sense to put some cases on the back burner. And then the immigration court isn't backlogged, right? And other cases that are priorities for removal can be processed through. Whereas when you have somebody who has an application for relief, there's no need to focus on them. All right. So matter of Castro-Tum complicated things a lot. Judges don't particularly like being told what to do. So I know that a lot of judges, or at least the impression I'm under is that many judges did not really like matter of Castro-Tum because they could no longer administratively close cases. And then it just frankly increased the backlog. And then there was this concept, well, we have more than 300,000 cases that have been administratively closed. Are we going to reopen all of those? Are we going to pursue removal for all these people? So these are important questions about, how effective is our removal proceeding process? And there was an individual in the Fourth Circuit. Now, the Fourth Judicial Circuit encompasses Virginia, Maryland, and this area, Mid-Atlantic. And there was a gentleman, immigrant, who'd had a case administratively closed because he had another procedure taking place with USCIS that required administrative closure in order for USCIS to process his application. Now, the immigration judge did not administratively close. He appealed. The Board of Immigration Appeals administratively closed. And then matter of Castro-Tum was decided. And in that mix of things, the government attorneys, had it reopened and said, you can't have administrative closure, move to terminate or something, but administrative closure should not be on the table for this immigrant. And the BIA kind of agreed with the government attorneys at that point. They looked at matter of Castro-Tum. They said, well, look, we actually don't have authority to administratively close. Sorry. That decision was ultimately appealed to the Fourth Circuit. And this is the case. And again, I just read it today. Zuniga Romero v. Barr. And so when a case is petitioned for review to a Circuit Court of Appeals, it finally leaves courts that are controlled by the executive branch of our government. So a little known fact that people don't realize is that our immigration courts are actually under the control of the presidential administration of the hour, which is why the attorney general, who is typically an appointee of the present administration, exercises this huge amount of power over the immigration court system. And we're seeing that sometimes to get justice, you have to get out of the immigration court system and get to a federal court, a separate and independent judiciary that is not controlled by the presidential administration. All right. So long way of saying now we get out of the immigration courts and we get to the federal circuit judges. What do they have to say about matter of Castro-Tum for this guy, Zuniga Romero? Well, the first thing that a federal court has to look at when they look at a case like this, and by this I mean, that interprets a statute and that determines, the bounds of its authority. Basically, the Attorney General in matter of Castro-Tum said, well, these specific regulations and statutes don't say anything about administrative closure. And then that was their decision. On appeal, the government argued, hey, look, we're the experts on immigration. And if there's a code section that's ambiguous in any way, then you, the federal court, need to give us, the agency, something that's known as Chevron deference or our deference. And so these names come from cases that have have gone through previously. Basically, the idea is if I'm a federal judge, I don't live and breathe immigration every day, but the judges in the Board of Immigration Appeals and the immigration judges, they do live and breathe immigration law every day. And so unless the statute or the laws that we're looking at are unambiguous, I should defer to their judgment. I should give them deference. I should give their decisions deference. And so that's this concept that, are the immigration courts entitled to deference? And there's been some building case law, and we'll talk about the Pereira decision from the U.S. Supreme Court on another day. But this is the first time we've had the Fourth Circuit look at the matter of deference in the immigration context. And what's exciting about this opinion is that they laid out their reasoning and said, hey, the agency is not accorded deference in the event that a statute is unambiguous, and that, we can just take the plain meaning and reanalyze it under our own lens, which is one of the reasons they used to support their decision overturning the matter of Castro-Tum. So they ultimately decided that courts can administratively close. But they said, hey, the statutes unambiguously give immigration judges the power to administratively close their cases. But then they also looked and said, hey, we also need to look to the general fairness of the practice. Like, how can an agency say that this is their ambiguous or unambiguous position or interpretation of this law if they've been doing it a different way for 20 years? And that's what they said in this case. They said, hey, look, since the 1980s, you've been doing administrative closure and you've been in agreement with it. You can't just do an about face and say, well, this is the only authoritative interpretation. Trust us, we're the experts. That was one of the other reasons that they struck down matter of Castro-Tum. But what's interesting about the reasoning of this decision is that the Attorney General has been very active in the immigration courts and in issuing these opinions. And so there have been other opinions that have come up, matter of AB, recently matter of LEA. And so these cases, what they've done is they've taken existing precedent, bodies of case law that have developed for years, and then essentially reversed course. And so what I expect to see in the Fourth Circuit, and of course I can't predict what the Fourth Circuit's going to do, but what I expect to see is this same reasoning saying, hey, government agency, why should we give you any deference if you're just reversing course on things that you agreed with? For example, matter of LEA has to deal with family-based social groups. In general, and in particular in the Fourth Circuit Court of Appeals, family is a social group for asylum purposes. Now, we'll have a full asylum discussion over a series of episodes soon. But, matter of LEA was basically the Attorney General coming through and saying family's not a social group, not anymore, not unless it fulfills certain narrow requirements. But for years, the immigration judges and the Board of Immigration Appeals and the Fourth Circuit in particular has strongly said over and over again that family is a social group for asylum purposes, and that it's a protected ground, that someone could claim persecution on the basis of being a member of a certain family, and they could gain asylum protections. That's very clear in the Fourth Circuit. So it's just interesting to see how this decision was worded, how the Fourth Circuit tackled the issue of deference, and what that means moving forward as the Fourth Circuit starts to look at appeals that will inevitably come where they analyze the impact of these Attorney General decisions, matter of AB, matter of LEA, being the ones that are on the forefront of my mind and my caseload. But the long and short of this decision is that matter of Castro-Tum, at least in the Fourth Circuit, is no more. Immigration judges can now administratively close cases. They can better manage their docket, leading to greater efficiencies. Now, will the government oppose administrative closure? It's been my experience under this administration that they're paid to say no. And so when we ask for things like prosecutorial discretion, the answer is no. When we ask to have things stipulated in terms of, hey, is this a social group, and certain legal arguments, the answer is no. And I don't think that that's necessarily the government attorney's fault. That is just kind of the priority that's been communicated to them. But at least administrative closure is now available, whereas it hasn't been in the past. So I've got cases, and I think I've already mentioned them, where they've got pending U visas. And in the past, I've asked for administrative closure, which is a reasonable thing to ask for. It takes 4 years to adjudicate. And then to deport someone with a U visa undermines the purpose of the U visa. The whole point of the visa is to protect people from deportation because they're helping our law enforcement agencies. I think I might take a look at some of those cases very closely and ask for administrative closure again. And so I think that this is a great decision. I think the Fourth Circuit has done excellent work. There is more in-depth analysis I'm sure that you can find, but I'm trying to give you the layperson an explanation of what's going on and why this is so important. And then also let you know that the Fourth Circuit has kind of set up how they're going to view some of these other Attorney General decisions as they get appealed up to them. So an exciting day for many immigration practitioners. Even though this is one of those blips in the immigration conversation, this one probably won't make headlines in the way that other topics that I've already discussed have made headlines. And yet it's important, and its implications are far-reaching. So that's it for Nation of Immigrants. Don't forget, you can follow us on iTunes, on Facebook, on YouTube, and giving you the real truth when it comes to immigration news here in the U.S. Thanks again for listening.
Thank you for listening to Nation of Immigrants.
America is a nation of immigrants.
Subscribe to the podcast on iTunes. Watch the live stream on YouTube and Facebook, or visit jacobtingen.com to learn more.